Okay, and the YouTube is live.
Okay, welcome everyone. Thanks so much for coming. My name is Belinda McCauley. I'm the Executive Director of the Beverly Hills Bar Association, and we appreciate very much everybody tuning in today. Based on the very large number of RSVPs we have today, I know that there are a lot of you waiting to hear from these speakers, so I'm going to keep their introductions very brief so that I don't take time away from the substance of this discussion that we could fill much more than our allotted time today. So their links to their full bios are in the chat. But as a little synopsis of the great expertise you're going to hear from today, first, Fatima Goss Graves is the president and CEO of the National Women's Law Center, which is one of the leading policy and advocacy organizations in the country. She spent her career as an attorney fighting to advance opportunities for women and girls. Widely published and a sought-after national media voice on her areas of expertise, she received her BA from UCLA and her JD from Yale Law School. Ederlina Coe is an associate professor at the University of the Pacific McGeorge School of Law. Ederlina brought extensive experience in the public and private sectors to academia, and she now teaches numerous courses, including reproductive rights and justice. Her prior positions include a long tenure as a federal career clerk and counsel at NARAL Pro-Choice America, where I should disclose we were colleagues for years. She received her BA from UC Berkeley and her JD from Georgetown University Law Center. Bridget Jackson is counsel at the Center for Reproductive Rights, which is one of the primary pro-choice litigation organizations in the country. Prior to her work at the center, she worked on federal legislative issues in the private sector. She received her BS from the University of North Carolina at Charlotte and her JD from Charlotte School of Law. Nakia Woods is the director of the California Coalition for Reproductive Freedom. CCRS is a statewide coalition of more than 40 organizations working to promote sexual and reproductive health, rights, and justice. Nakia is an expert on reproductive health care and policy in California, with a particular focus on Black, Indigenous, people of color, and queer communities. They are a graduate of the Dr. Beatriz Maria Solis Policy Institute. So usually at this point, I'd be turning things over to our speakers or a moderator, but I'm honored that our litigation section here at BHBA asked me to moderate today's panel. So I have a ton of questions for these speakers, and I know you will as well. Please feel free to drop those into Q&A, and we will tackle as many as our time allows. And now we'll jump right in. So we're here to talk about, as everyone knows, Dobbs v. Jackson Women's Health Organization, which last Friday became the Supreme Court decision that overturned Roe v. Wade and Planned Parenthood v. Casey. The court held 6-3 that the Constitution does not protect a person's right to choose to terminate a pregnancy, and that therefore states may ban abortion. So let's start with a big picture question. And this feels a little bit like asking you for the history of the world in, an elevator speech. But Fatima, can you give us a summary of what got us here? What's the road that led to this court and this decision?
Well, I'm so glad to be with all of you. And I'm originally from California, so I guess in some ways this is coming home. There are a lot of stories of how we got here. In some ways, maybe we got here starting in 1973, where groups of folks, similar to how I'm feeling in this moment, decided that they would never accept Roe and that they would dedicate themselves to a political project to overturn it. A project that was legal, a project that was political, a project that was cultural. And I have to say, many of us are making that same dedication now. So I could imagine that that's how they felt 50 years ago. Some of it has to do with the court itself, the Supreme Court itself, and courts generally, and whether or not the right devoted resources that are different from the left in terms of understanding and paying attention to the court. What we do know is that the court radically was remade over a very short period of time. So we went from, in 2016, having a court reaffirming Roe, and then again in 2020, although with the tweaks that we saw, to the shift of 3 justices in the span of 4 years, including 1 week before an election, and 1 in a seat that was initially supposed to be an Obama appointee seat. So when we think about what happened to that court, the reason it feels sort of distorted for many people in this country is that they didn't realize that the court had shifted so quickly and so dramatically. And what we have seen in this term is that the idea of long-standing precedent has had very little value as this court has reconsidered for the first time as if these long-standing cases didn't exist. And then the last thing that I just want to say about where we have been is that we have seen laws further restricting abortion access over the decades with an acceleration over these last 10 years. And in these last 10 years, what you started to hear, especially in the South and Midwest, is people saying, you know, Roe may still be the law of the land, but access doesn't feel real. Access doesn't feel real if there aren't access to clinics in my community, if I have to still drive hundreds of miles, and really if my people can't afford it. And we don't have a lot of infrastructure to change that. That was happening bit by bit by bit. And so when the acceleration came these last 2 years and states started passing not just laws that were sort of chipping away, shifting the rules around clinics, pretending to protect women's health, and instead passing laws that said we are banning abortion and we are criminalizing providers, that leap happened very fast and squarely attacking Roe, we had already had a gutted infrastructure in so many places in this country. So the current state of access that I know others will talk about is built upon an already long time eroded state of access in our laws, but also culturally. Culturally, this country got used to the idea that some people having far less access to abortion care and other reproductive health care services was okay.
So sobering summary of how we got here. And I think that's something we're going to touch on several times today is the distinction between the legalities in the decision and the realities on the ground. And one of the reasons Nakia is here today is to share those realities and how California is trying to make up some ground there. But next, I like, since we know sort of how we got here, for Ederlina to talk in broad strokes about the decision. And you're going to get into some more depth a bit later, I know, Ederlina, but can you give us a quick summary of what the Alito opinion, the majority opinion said, and how it went about overturning Roe and Casey?
Sure. Thanks so much, Belinda, for inviting me, and thank you all for being here. So as Belinda mentioned at the outset, in Dobbs, the court held that the U.S. Constitution does not protect the right of a woman or a pregnant person to decide whether or not to obtain an abortion. And in so holding, the court overturned nearly 50 years of precedent, starting with Roe versus Wade in 1973 and Planned Parenthood versus Casey in 1992, marking a pretty significant retreat from the court's constitutional role in declaring and protecting individual rights. So without this federal constitutional protection of the abortion right, the decision-making now goes to individual state governments. It goes to the federal government to decide whether or not abortion is legal and the contours of that right. And with respect to future challenges, future constitutional challenges to these forthcoming restrictions and bans, the Dobbs court made very clear that rational basis would apply. Rational basis offers a very strong presumption of validity to these laws. And in applying rational basis to the Mississippi statute, which banned abortion after 15 weeks of gestation, with limited exceptions for severe abnormality and medical emergencies, the court was easily able to uphold it, finding, again, there's no constitutional right under the 14th Amendment to the right to abortion. In terms of how the justices voted, the majority of the court, there were 5 votes to overturn Roe versus Wade and Planned Parenthood versus Casey. That was Justice Alito, Gorsuch, Thomas, Kavanaugh, and Barrett. The Chief Justice John Roberts, concurred in the judgment only. He would have upheld the Mississippi ban as constitutional, but he also made an argument for judicial restraint, saying that the court really didn't need to go as far as it did, and instead should have only addressed the specific question it granted on cert with respect to the viability line. So he would not have gone so far as to overrule Roe and Casey. Justice Thomas and Justice Kavanaugh wrote separate concurring decisions. And then, of course, there was the dissent, Justices Breyer, Sotomayor, and Kagan, whose dissent is grounded in an interpretation of the Constitution that protects a woman's right to decide whether or not to obtain an abortion, noting that to hold otherwise or to allow the government to permit to be able to make that decision for her takes away her liberty under the 14th Amendment.
That is the most succinct description of the case I've heard. Thank you so much for that. I know that there are a ton of other details, especially as a law prof, that you want to get into, and we will get into more of those later in the conversation. I'm trying to do kind of an overview here to start with. And on that note, Bridget, can you give us a sense? There's been so much coverage of trigger bans. They're a term that I had never heard all my years in repro rights, zombie laws. I had just known them as the pre-Roe bans, enjoined or otherwise. And then there are new restrictions that are brewing in the states. Can you give us a sense of what the situation is in the states? We're going to put up a graphic that's a summary and a link in the chat to What If Roe Fell, which is the Center for Reproductive Rights' very excellent resource about state by state what's happening and changing daily. But if you could give us an overview, that would be really useful information to those of us who are not in this day in, day out.
Certainly. So what we're seeing is that many states, specifically in the South and Midwest, have become emboldened with restrictions and laws that will essentially restrict access to abortion care. Some of these laws, like you said, are zombie laws and trigger bans. And so what a zombie law is that's a law that has already been struck down, but not removed from the statute books, and could therefore be revived. So in some legal systems, a final ruling that a law is unconstitutional results in the erasure of that law from the statute books. But in the United States, however, constitutional adjudication doesn't work that way. A state legislator or in a case of federal law, Congress might choose to repeal a law that has been struck down as unconstitutional. But if it does not, a ruling of unconstitutionality merely forbids the law's enforcement. So there could be a law banning abortion in a particular state, although prior to overturning Roe, that would have been unenforceable. Additionally, some of the states are enacting trigger bans, as you mentioned, which would automatically ban abortion now that Roe v. Wade is overturned. So as expected, states have wasted no time in moving to enforce these trigger bans and other bans as well. So the situation, like you mentioned, is rapidly evolving, but already abortion is unavailable in more than 10 states. So for example, prior to Friday's Supreme Court ruling, which overturned Roe, abortion was available in Texas up to 6 weeks gestation. Since then, all abortion in the state have essentially ceased. If plaintiffs are successful in blocking the enforcement of the pre-Roe ban, some abortion providers in the state would resume abortion care up to 6 weeks, which would provide critical, if only temporary, relief for Texans with a very early pregnancy, as access to abortion is essentially being decimated in the southern United States region. So 13 states across the country have signaled their readiness to ban abortion by passing trigger bans, which again would effectively ban abortion immediately. And it is likely that half of the states across the country will try to ban abortion. And as previously mentioned, this is going to leave the most vulnerable unable to access abortion care, which is, of course, an essential healthcare need. So due to racism and other forms of discrimination in the US, the impact of this decision is going to disproportionately harm Black people, Indigenous people, Brown people, and other people of color. It will also impact women, those economically disenfranchised, young people, immigrants, and members of the LGBTQIA community. So it's just really important to really center this around the communities that are going to be most affected by this decision.
Absolutely. Thank you for putting a fine point on that. And it's something I want to do throughout today's discussion. And earlier when I mentioned the legalities versus the realities, I think that's a huge distinction, right? Is that on paper, the decision may apply to all women, or at least all women in states that are likely to ban abortion or already have, but in reality, low-income women in particular, and who are disproportionately women of color, will be the most negatively impacted by this. So on that note, I actually want to ask you, Nakia, because this is your area of absolute expertise. What is the practical impact of this decision in California? I know that your organization includes organizations that represent providers, and that later on we'll talk a little bit more about some of the things brewing legislatively. But if you could give us a sense of the immediate impact and what you're seeing, and the how different communities are being affected, that would be, I think, really useful insight.
Yes. So one thing that I want to say, because I'm always this person in all abortion and reproductive justice spaces, abortion impacts not only women, but non-binary and trans folks. And so just reminding all the folks that are on this call, abortion is not a women's issue, it's a women's issue, it's a people's issue. And really reminding folks that, yes, we know that white women are definitely going to be impacted by this. And we put folks that are on the margins of the margins in this conversation, at the forefront of this conversation, recognizing that the resources and the way that historically that folks of color are penalized and persecuted looks very, very different than it does for white folks. And so making sure that y'all understand that. So when we are saying this is who it's going to impact, we're talking about statistically, yes, we are going to be the first people that are being charged. We're going to be the first people, when we're talking about legality, we're going to be at the forefront, unfortunately, because that's how criminalization works in this country. But to get back to the point of what does this look like for folks, for providers in California? We've already seen with these different trigger bans, or even prior to some of the bans that happened, like the ones in Texas last year, we've seen our providers being flooded with calls from out of state because people don't know what to do. And they know that California is a safe haven, right? We understand that Roe definitely was Roe was the floor. People in California don't have great access to abortion, even though we have great legal standing, right? And abortion is legal here and it will continue to be legal here. I just want to make sure that I say that. And there are thousands, actually probably millions of people that do not have access to abortion simply because they're in rural areas and don't have the money to drive. We're talking about driving hundreds of miles, right? California is very large. Some folks are having to drive hundreds of miles to get to an abortion provider. And so what we're seeing is the providers that we have in California are already understaffed, under-resourced. We don't have enough doctors. We don't have enough nurse practitioners. We don't have enough midwives to provide these services. And so it's really just a jump. It's really just gonna continue to increase and increase and increase. And it's gonna be really heavy. So that's why we're also encouraging folks, if you do know a local clinic that is providing abortions, if you do know organizations, and there is a list that I think will be shared in the materials, volunteering and donating. I think the other thing that we're seeing that's happening with providers and folks that are offering practical support, people are just confused. They don't know what's happening. So they're either afraid and not showing up to their abortion appointments, or they're again, we're getting hundreds and hundreds of calls, hundreds and hundreds of emails. And so thinking about the capacity of everyday folks at a lot of these organizations, they're not well funded, they're small. So you do have, again, at Access Reproductive Justice, one of the only abortion fund in California, they only have 2 staff that are manning that hotline and taking in all of those calls. So it is really putting a strain on providers. And when we talk about policies, and we'll talk about policy in a minute, right? There are policies that we're trying to push to increase the amount of folks that are able to perform abortions without supervision. We are pushing for trainings, for funding to go to train folks to be able to provide these critical services, recognizing that, again, there's going to be a ton of people coming from other states, A, and then B, we also need to just increase access for people that are already in California. And so, again, it's one of those things where this court decision is really highlighting where our infrastructure was already crumbling and not doing that well. And on top of that, now we're trying to put more on our providers, more and more on the folks that are offering this practical support.
So already difficult implications here in California, although we know that among states, we are the most protective. The next two questions I have are about what's in this decision and what's not. So one for Ederlina and one for Fatima. The first, Ederlina, is for you. Can you give us a little more depth on how the decision went about overturning Roe and Casey, and also the really the evisceration of substantive due process? We had a question from one of our audience members about what is substantive due process. So if you can give us the quick primer on that and how the court addressed that, that would be great background for those folks here who haven't had a chance to read the very voluminous opinions.
What is substantive due process? That is the $64,000 question of the day now after Dobbs. So let me just encourage everybody, when you do have the time, to take the time, get a cup of coffee or a glass of wine, whatever it is you choose, and read the decision. It will really paint a picture of the different factions that exist on this court and the different ways to read the interpretations of the Constitution. So let's start in a nutshell with the majority decision. The majority decision takes an originalist approach to the Constitution and reasoned that the abortion right is not protected by the Constitution because, first, it is not mentioned or there's no express reference to the right to abortion in the text of the Constitution. Second, the 14th Amendment's Liberty Clause cannot be interpreted to include the right to abortion, at least according to this court, because it is not deeply rooted in the nation's history and not an essential component of ordered liberty. And so how did the court arrive at that decision? Well, that conclusion was reached because the court looked at history. Well, at the time the 14th Amendment was ratified, did it protect the right to abortion? Was the right to abortion protected at that period of time? Of course it was not. Women didn't even have the right to vote or equal citizenship or status in the country. But the court nevertheless bypasses that idea and concludes, look, there's no support in American law for a constitutional right to obtain an abortion. And even though during the common law period, pre-quickening abortion was permissible, that doesn't mean that states weren't allowed to restrict the abortion right. They just didn't. So third, what the court held was that the abortion right is also not part of what it calls an entrenched right, or what we know of as the right to privacy. It's not supported by precedents like the right to contraception or the right to marriage or the right to child rearing. In this court's view, abortion is distinguishable from those other substantive due process rights because it involves potential life and because it involves a critical moral question about abortion. So at this point, this is one of the junctures in which the court says Dobbs shouldn't be read to undermine other decisions related to the right to privacy. And then finally, the court goes through a lengthy discussion of stare decisis. For the non-lawyers on the call, stare decisis is a principle that courts use to ensure predictability, reliability, and consistency in the law. It means stick with what has been decided. After going through a series of factors, the court decided that stare decisis counsels against retaining Roe and Casey and overturns those decisions. So with without federal constitutional protection, what standard will govern constitutional challenges to future laws? The court says it will be rational basis. So laws will be sustained if there is a rational basis on which the legislature could have thought their law would serve legitimate interests. The court lays out a series of interests that would be approved seemingly under rational basis, including the respect for and preservation of fetal life, protection of maternal health and safety, elimination of certain abortion procedures, and so on. Now, the majority's opinion was certainly not the only way that the court could have decided this issue at the outset. I mentioned that if you read the entire decision from beginning to end, what you'll see are starkly different views about how to read and interpret the Constitution and this court's 50 years of precedent, beginning with Roe versus Wade. The dissenting opinion offers that contrasting view of what they call the court's pinched interpretation of the Constitution. For the dissenting justices, they read the Constitution as including a realm of personal liberty that the government may not enter, specifically that liberty as it relates to bodily integrity and family life. Yes, they acknowledge that some conduct that is protected by this personal liberty is not enumerated in the Constitution. It was not protected by the 14th Amendment, but that does not matter because the Constitution is a document that is designed to endure for the ages of time. The Supreme Court, until Dobbs, has not frozen the Constitution in time, but rather courts have interpreted liberty, they have interpreted equality in ways to bring in individuals that were previously excluded, such as women. And so the dissent explains that this method of constitutional interpretation does not turn judges into policymakers. Rather, they are still bound by constitutional principles. They're still bound by the whole course of the nation's traditions and history, as well as the evolution of the Supreme Court's precedent. Roe and Casey are part of these core constitutional principles related to individual freedom, related to equal rights and personal liberty, the same principles that apply to your right to contraception, procreation, and marriage. And although abortion may be different in the view of some, the dissent reminds us that prior courts recognized that and struck a balance as a result in both Roe and then in Casey. In looking at the factors of stare decisis, the dissent basically boils it down to there have been no significant legal or factual changes in the law or in society that would support overturning Roe versus Wade or Casey. And the only thing that has happened that has resulted in this decision is that the majority now has enough votes and they have now substituted the rule of law with the rule of these individual judges.
Thank you for that summary, Ederlina. I thought the contrast of the two opinions was, of the majority opinion with the dissent was especially interesting. And Fatima, I hoped that you could address what I thought were two of the biggest absences in the majority opinion. And that is first, there was not a discussion really about women or about pregnant people. There was not a discussion about maternal mortality and the racial disparities that are built into that as there was in the dissent. The other thing that was noticeably absent was any response to the dissent's focus on reliance, that for 50 years, U.S. women have relied on this right. Can you talk about that or other takeaways that you had from the opinion?
Yeah, if you read the opinion, women as a category and pregnant people generally were pretty absent, and the impact of the undoing 50 years of an understanding of the right to legal abortion in this country and what it would mean for people in community, again, relatively absent, except for a few asides around all the progress that women have made over the years. And you know, it was especially ironic that Mississippi was making this argument in the Supreme Court and that Alito took it as fact, given that Mississippi on so many measures ends up ranking last, and its dramatically high maternal mortality rate, especially for Black women, and the fact that just this year it failed to pass a real equal pay law, and the fact that none of the 26 states that joined together to ask the court to overturn Roe even have a paid leave policy. So, you know, if you were reading it, you might have thought, well, what precisely, which world are they talking about in a time during a global pandemic where we still have over 650,000 women who have left work, who have not returned to work and aren't looking for work, in large part because of care. So it was sort of really difficult to square that. Also difficult to square the two generations of people who have come up accustomed to the idea that it is not a violation of criminal law to decide whether or not you are pregnant. And the many people who had trust and faith in the Supreme Court who are just waking up to this new reality and seeing in their states this idea being hotly debated as if whether or not you are an equal citizen who gets to control your life, your future, your participation in our economy, in our politics, in our society, that's a totally new idea for many people. And so that is part of what we're seeing. And then the last thing that I want to just name, and to go back to the historical telling that Justice Alito provided, which was, of course, so awfully tailored. Professor Michelle Goodwin had a wonderful piece this last week that if you haven't seen it, I highly recommend it, where she reminds everyone that he totally left out the real history of sexual coercion and forced birth in this country of Black women during slavery, that in fact, that the premise of slavery was in part built on those two ideas of not being able to control your reproductive destiny or whether you parent, allowed the trade to continue. And so no mention and understanding of the 13th Amendment and its relationship to the telling of the history that Justice Alito told, or the history of how we even got to the 14th Amendment and the conversation around who really is an equal citizen and what it means to have due process and liberty in this country, or the 19th Amendment. There's no conversation there and what that political project meant to decide that the right to vote was the right to be able to participate in the politics of this country, which was hinged upon your ability to participate in our economy and our society, totally absent. And no mention of, the favorite folks who he was quoting in this time, and the idea and understanding and treatment of women at this time. We are talking about a time where legally and certainly culturally, women couldn't have lines of credit, couldn't own property, couldn't protest against marital rape. You legally didn't own really the right to control your life and future. So when you talk about deeply rooted in our history, if you take that idea and notion, that is the part of the decision that I think everyone in this country should pause on. Because the only ones who have had deeply rooted freedom in our history and culture are a small group of powerful people that don't include people like me. So I actually think, though, that if you think about all the things that were missing from his narrow view of not just what our Constitution requires, but our history of our society and women as a stakeholder that mattered, and gender roles as a thing to consider, it sort of opens up a direction for the rest of us, the vast majority who do actually support reproductive freedom, around the project and story we must tell.
Yes, the selective history is something that definitely jumps out. I thought that the dissent did a very good job at responding to that, although I think you could still write hundreds more pages about it as well. One of the things that, as you're reading the decision, I think whether you've been in this space or not, your brain starts spinning with, holy cow, what are the courts going to look like for the next couple of years? That's separate and distinct from the more significant impact on real women. But the litigation potential is never ending, it seems. So, Bridget, can you talk a little bit about what we're already seeing in the news, what some of the litigation plans are with respect to trigger bans, with the zombie bans, so the pre-Roe and older laws, and what the next couple of years looks like in terms of abortion jurisprudence?
Sure. And first, I just want to say that this retrogression of our fundamental right, this essential care that we need, it's absolutely devastating. And I just want to really ground people with what this really means for so many people, especially in the South. The maternal mortality rate for Black women are 3 to 4 times higher than for our white counterparts, regardless of region, education, income, etc. And so for a lot of people, this could be life or death for them. It is life or death. And so with that, the center's immediate priority is maintaining access in every state for as long as possible. Every week, every day that people can access the care that they need and make decisions that are best for themselves and for their families, again, will protect their health and their lives. So the center and our partners have already filed legal action to try to restore or preserve access in Louisiana, Texas, Mississippi, and Arizona, to name a few. We will be filing more cases in the upcoming days. In Louisiana, we are challenging 3 trigger bans in the state court. In Arizona, we, along with our partners at the ACLU, are challenging a personhood law that is currently in effect. In Texas, the center is challenging a pre-Roe ban that has luckily been blocked at least until July. And lastly, in Mississippi, a trigger ban and a 6-week abortion ban is being challenged as well. So overturning Roe has certainly not put the issue of abortion to rest. Eliminating Roe is not the end game of these anti-abortion movement partners. And they will continue to push for a nationwide ban on abortion. So we have to just keep fighting any way that we can.
Yeah, we're going to talk about the potential of a nationwide ban later, because with the supremacy clause, it's a reason for people in California and other states not to feel too comfortable. The first thing, though, that I wanted to just talk a little bit more about, which you addressed a bit just now, and it's something, Fatima, that I know that the National Women's Law Center focuses on quite extensively, and that's the disproportionate impact of this decision, and particularly on low-income women. Can you talk about what you are already seeing, or what all of the statistics say is next in terms of the direct impact of the decision?
So let me talk to you about what we're preparing for. And again, I said earlier that we haven't actually been in a world without Roe, with income inequality as widened as it is, with technology in the way that it is. And so someone earlier talked about contact with the criminal justice system and who is most likely to experience that. I have to say, so it is not just having that contact, it's all of the many systems in this country that are built off of that, whether it is your housing, your ability to access benefits, your ability to stay employed. All of that is deeply connected. When I think about who can make a decision to travel and to be gone for multiple days, it's people who actually have leave and possibility to take leave from their jobs. It's people, the majority of people in this country who have abortions are already parents. So what does it mean to be able to have childcare and someone to care for your family so that you could go access care well outside of your community, and potentially doing so be ensnared in legal ideas that might put you in contact with the criminal justice system. It's who might go to the hospital if they are in need because they need more support following self-management, and who decides that that risk is too great to bear. It's whether or not people now have insurance plans that can cover access to abortion if they travel outside of their states. People don't just have an abortion fund waiting in their savings account just in case they end up needing one. And and we have a deep infrastructure of abortion funds in this country that do heroes work. There is no way to fund ourselves meaningfully out of the crisis that has now been exacerbated fully. People who have the least access to healthcare, who have the lowest wages and are in workplaces that are already the sort of workplaces where all the flexibility is in the hands of the employer and none of the flexibility is in the hands of the employees, they're going to be the hardest hit. We saw what happens when a group of folks are most deeply and hardest hit at the start of the pandemic. Like, what does that look like? Who's hit the worst? It turns out it was women, and disproportionately Black and Latino women. 1 in 3 Black women work in jobs that are frontline jobs that have not the sort of supports and resources that jobs in this pandemic looked like, where you were able to telework and not have to be on frontline and be safe and have a different experience around childcare. So we're entering a totally new phase. And I will say we are inundated with calls from folks who are not only the people who are the patients, who are in the category of folks that I'll just call them the helpers. People who in their day-to-day engage with people who will need access to abortion care. Do teachers end up being mandatory reporters? What about the nurses? Who's finding themselves in situations where a condition of their job now means they're spying on people who they want to provide care, or they themselves are now subject to a criminal or a civil regime? They have unleashed a whole new idea that's going to fall really deeply on our communities. And every time I begin to think about it, I am just simply more and more enraged.
Yeah, the enormity alone, before you even get to the reaction, the enormity is really hard to grasp. Every time you think about it, there's more and more impacts. Nakia, are you hearing from any of the groups within your membership that deal with providers or represent providers that they are concerned about, legal exposure? And are they, looking for counsel to protect them potentially against other states' laws?
There we go. Let me unmute. So we actually, that's been like a huge conversation that's happening, not just within our membership, but with providers in general, thinking through not only the legal ramifications for providing abortion services, but also thinking about like telehealth services. What does that look like? What does that mean? Also thinking about the fact that these folks are doctors, they are not lawyers. And so they don't have a grasp of the law in the ways that, again, like most of the folks on this call do. And so then there is that that impact of fear. Am I able to provide an abortion if I go to this state How do I make sure via my telehealth work, some of the folks that we work with provide telehealth, how do I make sure that I'm protecting myself while also wanting to provide this, this critical service of providing abortion? There are some policies, and forgive me, I can't, the numbers pop is leaving my head right now, but there are a ton of policies that are being kind of introduced in California to protect California providers specifically. And so if you want to learn more about that, I'll go ahead and I'll put it's from the Future of Abortion Council. I'll put those recommendations in the chat so you can see what those look like. And at the end of the day, we know that what is law and what is enforcement? Like, how do we protect people in California if another state is coming in? Also thinking about the cost, right? Not all of these providers are folks that are necessarily making enough money to say, I have a lawyer on retainer. So even if there are laws that are protecting providers in California, if there is a court case, who is going to protect them? So like just thinking of all of those implications, and then on top of not just the legal ramifications, and I'm sure again, folks that are on this call understand this, thinking about the safety, your own personal safety. As a person that's saying abortion needs to be legal, like I'm fighting for abortion access, and those things, I'm a provider that provides abortions. These folks are being targeted by aunties, right? And so then there's that added layer of, now I need to figure out, how am I going to be secure? How am I going to protect myself and my family? Folks are taking their information off of websites, and which again takes away access, because now you don't have groups of people to look for resources simply because they may be attacked. And so it's like, the law is one thing, and then thinking about the day-to-day, like these are providers that may not even feel safe or comfortable providing abortions that they know are important. And so it's an all around just kind of crappy situation, and thinking about the fact that when these decisions are made, and I appreciate one of the questions in the chat was like, so like, are we going to sue these like lawyers for practicing medicine? Because in essence, that's what they're doing. They're making medical decisions for people without any medical degrees and having no understanding about reproductive care. And so again, like, it's a lot of ramifications based on that a group of people made a decision about that have no expertise.
So you dovetailed that perfectly into what we were going to talk about next, which is what is next and what could be next. And I think the parade of horribles that you've already discussed, that we've all discussed, are already happening. One of the things that was notable, and Ederlina, I'm going to have you address this, notable about all of the opinions, but particularly Thomas's concurrence, was this idea that all substantive due process rights should be on the table. The majority goes to great pains to say, no, abortion is different, as you said earlier. The dissent goes to great pains to say that doesn't actually make any sense, since all of these decisions were grounded in the same line of reasoning and the same substantive due process right. And I should note here, just as a little promo note, but also just so you don't feel like you have to cover it in your time, we're going to do a separate CLE specifically about the potential impact on LGBTQ equality post Dobbs in July, and I think my colleague's going to drop an RSVP link for that into the chat. But what is the potential impact on these other substantive due process rights, and what do you think about Thomas's concurrence? Because I thought what was notable about it was that it said so much more than he had to, right? It was a very sort of unnecessary flourish, but quite a roadmap of the potential perils to come for those other rights.
I think that's exactly right. So at least for a lot of people, it is very hard to put trust in the assurances that are offered in the majority opinion that Roe and Casey must be overruled, but all of these other substantive due process rights don't. whether they were recognized before or after Roe versus Wade. And the reason is because the reasoning that the court uses to overturn Roe versus Wade is solely based on the legal status of the right in the 19th century. In the 19th century, the law did not recognize or protect rights related to same-sex intimacy or same-sex marriage, related to interracial marriage, related to contraception, related to the right to not be forcibly sterilized. So if you're going to use that court's reasoning, this means one of three things. Either the court doesn't buy its own reasoning, or these other substantive due process rights are indeed at risk at some point in the future, or this court is going to selectively apply this originalism reasoning when it suits their outcome. As to Justice Thomas's concurring opinion, where he does say it is time to reconsider these other substantive due process precedents, including the right to contraception, the right to same-sex marriage, and same-sex sexual intimacy. I think some people are going to be very quick to dismiss Justice Thomas's concurrence and say, well, he's the only one. He sort of stands out there on his own. However, his opinion is now published in the US reports. It is now authority. Even if it is not binding, it is now up for grabs for citing, for using as support for different arguments. And so you can expect it to be seeing those arguments. Many people would have not thought that the arguments that are being offered now would become law. But again, once you have enough votes, suddenly it becomes a majority opinion. So even if the votes are not there now, at some point, Justice Thomas's view may prevail. See Roe, see Casey.
Yeah, that was, in reading it, that leapt out is it seems like much less of an outlier when you read that immediately following the majority opinion. Fatima, one of the responses that's being discussed to all of this is codifying Roe at the federal level. Wondered if you could share, first of all, what you think the reality is, both the reality and the legality on that of Congress doing so. And second, whether you think this Supreme Court would uphold a federal statute that codifies Roe.
Yeah, and well, so I should first say where we are with the Women's Health Protection Act. It has passed the House, and it has been twice brought up in the Senate, and it has fallen shy of an ability to move forward. The last time around, we basically got 49 votes in favor of it. And so there are a couple of questions, and I understand folks being discouraged by what happens in Washington, especially with the filibuster, which has meant that a minority of folks in the Senate and deeply a minority of folks in this country can block much of important things from happening. And that's sort of our reality unless there is a shift in the rules around the filibuster. So do I think there are prospects for this Senate to pass WIPA with the current makeup of the Senate? Likely not, right? Do I think it's possible that the current makeup of the Senate could change and they could pass WIPA? Likely so. It would require a change of the filibuster rules in a Senate that looked different. So, I mean, that's where we are in terms of the Women's Health Protection Act. If I could just say one thing about what it does, it would codify, it would effectively codify Roe and Casey. I know there has been some public confusion over whether it would do that and what it would do. But it is a bill that has, again, passed the House this year. And so when people say, what has the House done? Are they going to do anything? I think some House members are like, well, we did the thing. And so that is what you're seeing in some of the back and forth. Would the Supreme Court say that it was valid? Well, WIPA is grounded in two different ways. It is grounded in the authority under the Commerce Clause and the authority of the 14th Amendment Equal Protection Clause. Now, I don't know, given what all of the dicta in the opinion about pregnancy having nothing to do with equality, with sex-based equality in this in this country, sort of reviving Geduldig in ways that feels misused after, again, many cases between Geduldig and today. But it was also dicta, and I don't think we have had a full airing and opportunity to make an equal protection argument to this court. Given the state of the court, am I hanging my hat on this court as comprised in the way that it looks today? Not very much. But I also know the court of today is not the court of tomorrow. And so what I expect we, and the collective we, will all be doing is situating a new right and access to abortion under existing laws and creating new avenues, really driving a campaign to put us back in the Constitution.
So a roadmap, it might be a longish road, but it is a roadmap. And a bumpy one. The interesting thing that that sparked in my mind when you were talking about equal protection, and actually went in the majority opinion as well, is, and Ederlina, I think you and I discussed this law review article a long time ago, which is there's a relatively famous article by Justice Ginsburg from before she became a justice, in which she argued that instead of, as Rose holding, grounding the abortion right in privacy, substantive due process, she would have approached it from an equal protection perspective as sex discrimination. Are you seeing more of that argument? Either, obviously, we're seeing it at the federal level with the federal bill, but is that going to be another argument that's made at the state level, and then as a way to incorporate into state constitutional protections?
Is that to me?
Yes, sorry.
So I imagine, and I'll defer to Bridget on this, as to how much they are using the Equal Protection Clause. I know that there are a number of states, very few, but there are a couple that have equal rights amendments explicitly in their constitutions. And could those be used to be read expansively to include the right to protect an abortion? I think there's some history that might work against it, because I know that in the politicking of the Equal Rights Amendments, some states will say, no, this has nothing to do with abortion, even though obviously having the right to control when you have children is central to your equality. But I imagine, given the door slamming shut on substantive due process, that the Equal Protection Clause is where we will turn to next.
Got it. Bridget, what else are you seeing in the states? What are we going to see legislatively over the coming months and years?
That's a good question. And given the current makeup of the states, it's really difficult to see where things are headed, right? Like, who thought that we would be here just a few years ago, even a year ago, right? We are seeing some states provide proactive constitutional amendments. There are safe haven states that are expanding access to abortion care. California is a really great example of that, although, as Nakia mentioned, that still does not make abortion accessible for many people. And so truly, I think we've covered quite a bit as far as the landscape of where we are with abortion access. And truly, we're just going to have to wait and see. We're going to keep fighting. For swaths of this country, probably about half, abortion is going to be inaccessible, especially in the South and Midwest. And that's just currently where we're sitting.
Thank you for that summary. I know that as model legislation develops from some of the groups that had opposed Roe and supported the overturn, we'll probably, if history is a guide, we'll see similar measures enacted in lots of states with similar politics. One thing that I think provides a lot of people here in California with comfort is that our statutes and our current legislature are quite protective of the right to choose. I know that there are several measures being considered, and actually I think one just enacted. I think the governor just signed another one. Nakia, can you give us a quick sense of what you see on the immediate horizon that people might want to look out for in terms of pending legislation?
Yes. So right now, the Future of Abortion Council, we had a recommendation. I shouldn't say we. I'm not necessarily. I'm in there, but I'm not on the steering committee. We have 75 recommendations that we brought up last year, right? When we felt like, all right, this is happening. This is like very real. We need to gear California up to be that safe haven, right? And so we currently have 16 bills and policies that are that hopefully we can see get passed. Some really great examples of those bills. I'm thinking about abortion access and increasing access. Is thinking we have like AB 2134, which is providing gap coverage for folks. We have AB 245 that is eliminating cost sharing. But then we also have, this just happened on Monday or Tuesday, SC 810, which would make abortion a constitutional right for California's constitution anyway, right? And so there's a ton, and like I said, I put the FAP Council bills in there, but there's a ton of recommendations. I think one of the most important things that if you have the ability to vote, if you have the right to vote in California, because we know it's all messed up, please get to the polls, because you know who is showing up? Folks that are anti-abortion. And so we need to make sure that in CCRF, the California Coalition for Reproductive Freedom, we are currently working on a reproductive freedom legislative voter guide for folks to be able to look and see these bills. Because honestly, if you're not a policymaker or a lawyer, sometimes when you read these bills, they're so confusing. You don't understand what you're voting yes or voting no for. So we will be creating a tool to share out for for Californians that have the ability to vote. But all that to say is, like, we are working hard. We're working diligently. We're trying to partner with other states that have abortion, that will continue to have abortion be accessible to all folks that can get pregnant, to really strengthen ourselves. I guess that's the way I want to say it. And then also figuring out how can we support our siblings in other states where we know that abortion is no longer going to be accessible. It gets a little tricky because, again, a lot of us are not lawyers. And so it's like that law piece. So for the lawyers on the call, I'm going to recommend that if you have the capacity, it might make sense for you to try to volunteer at these organizations and supporting folks, because y'all have a legal expertise that we do not.
Actually, Bridget, I had a link that I was going to drop in a bit later, but I think the center has a program, right, for lawyers who may want to provide pro bono counsel or receive training to be able to help.
We do have a few trainings that we're currently doing. So those that are interested in pro bono resources, please feel free to reach out to me. And I would be happy to connect you with the appropriate parties.
Great. So when we're talking about California and it being a safe haven, that's all dependent on there not being a federal ban, which a federal ban is now possible because of the majority opinion's reasoning, removing the constitutional basis for the right to choose. So Ederlina, can you just on a very basic level let us know, because for some of us, it's been a very long time since con law. What happens if there is a Congress, an anti-choice Congress, and either an anti-choice president or margins that can't be a veto that can be overcome in the Senate, and there is a national ban that's passed? What happens to California's constitutional protections, those in other states, statutes, anything that provides additional protection?
Right. So the dissenting justices raised this as the most threatening possibility, right? That the court's decision would open the federal government to now prohibiting all abortions and maybe not even offering any exceptions for rape and incest and other scenarios. If that happens, if Congress passes a law that is signed by the president that bans abortion, that federal law will prevail over individual state law, over individual state court interpretations, and over individual state constitutional amendments. Under Article 6 of the Constitution, the Supremacy Clause basically says federal law, so the federal constitution and federal statutes will take precedence over state law and state constitution and statutes. Now, historically, when we think about regulations of abortion, it typically comes up from the different states, but it's not as though Congress has not staked its claim on this issue either, right? When it passed the Partial Birth Abortion Act of 2003, that was a nationwide ban, and that was upheld by the Supreme Court, a Supreme Court that many people think is far more progressive than the court that we have now. So it's, it is cold comfort in California. It's, we are as a state bringing big energy, right, to the project of protecting reproductive freedom in the state, but it is, we are not completely insulated from a ban if it comes at the federal level.
And I know that there's still a lot of open questions about the intersection of different state laws, right? Kavanaugh goes to pains to say there's still a right to interstate travel. So, essentially Californians don't worry that you'll be in danger of helping, people from Texas, but I think not entirely clear based on the majority opinion, whether that opinion will hold because abortion had a special carve out of substantive due process. It does not seem entirely clear to me that there wouldn't be a special carve out of other constitutional rights if you're talking about abortion, because they say there is this other compelling interest of potential life that allowed the carve out of substantive due process. So as we sit here in California, though, and we do have that big energy, Fatima, from the center's perspective, what can we do in states like California to be useful, particularly as lawyers? I know Bridget said that they have a project, Center for Reproductive Rights. What is most helpful if this is an issue that we care about as lawyers that we can do right now?
Thanks so much. And my Zoom and computer restarted, so I think I missed that part of the conversation in virtual world. And so I think I heard two things. One, there is a promise of a nationwide ban convention. Take that promise very, very seriously. I don't think people should assume that California's laws that we write by their own people and go outside its borders will be enough over time. So everyone will have a vested interest right now in what happens in terms of abortion access. And I think folks I'll try to move forward until my computer gets back on. The second thing, we have a legal network at the National Women's Law Center, and I hope for a long time have had a small project where attorneys have represented
Fatima, we cannot hear you. I apologize. So I don't mean
Let me work on it.
There
Give
you
me
go.
just a
Now we
second.
can.
You can hear me now.
Now we can perfectly. Yes.
Okay. Have you ever heard anything I've said? Just this. Should I start over?
It was hard to hear and then impossible.
Okay. All right. Well, so the very short version of what I was saying in terms of how can lawyers help? I was saying that we have a legal network at the National Women's Law Center. We call it the Legal Network for Gender Equity. Many of you may be familiar with Time's Up Legal Defense Fund, where we have funded cases related to harassment and related retaliation. But attorneys sign up for our network to take on a range of cases that matter to the lives of women in this country. And for a long time, many attorneys have been representing individuals who are providers who are seeking to provide care in their relationships with their employers, in their relationships with the various rules and regulations through their state. So part of what we are looking at right now is how to provide support and expand that network. And I encourage folks to sign up through our website. The other thing that I would say in terms of what can lawyers do, we touched on even just a little bit the range of really complex legal issues that we are grappling with in real time and will continue to grapple with as the state of the laws in the state level change. And so organizations are racing to keep up with this. I think if you supported any number of organizations that are focused on and concerned about reproductive rights, health, and justice, it would be of huge value to help people understand their rights, the opportunities. And then one last thing, we're in the position and posture of dreaming up solutions for the future. And that is a place that lawyers sometimes do well. Maybe not always the dreaming part, but certainly thinking up the potential for a range of laws and policies in the future that can make a difference.
Well, that positive note is welcome, and maybe the first one we've had in this discussion, understandably. So thank you for that. I'm going to get to some of these questions from the audience because we have some excellent questions. One of them, Adelina, is for you. So last week, the day before the Dobbs decision, we had the case, the Second Amendment case out of New York, in which the Supreme Court invalidated New York's 100-year-old concealed carry statute, saying it violated the Second Amendment. And the question from the audience is, how can states regulate pregnancies, according to the theory of the Supreme Court, but not guns? Particularly given this historical analysis that the court engaged in?
I mean, I think the short answer is we're talking about two different constitutional amendments, one of which this court is willing to interpret rather expansively, and one which it is now clear is willing to or is motivated to interpret very narrowly. And so the tests that apply to a Second Amendment challenge versus one that is challenging restrictions on reproductive rights is going to be very different. Okay, so that being said, I do want to say, and this is a bit of a betrayal to the profession here, but we speak a lot about this court. And I think for a very long time since the Warren Court, we have been feeling comfortable, if not complacent, in the rights that we are demanding from our government and where the boundaries are drawn in terms of our rights and our privacy. And we have to begin thinking outside of the box. As Fatima mentioned earlier, this is a court that is going to be around for a while. And the decisions that they are going to be releasing are not going to be favorable. And they don't seem to be taking any half measures here. They're coming for everything and everyone pretty aggressively. So when she encourages us all to think outside the box in terms of law, I mean, it is worth thinking, how do we ensure and shore up these rights? How do we change hearts and minds? And thinking outside of the federal court system, even though historically the federal court system has had a role in protecting our individual rights and liberties, right now it seems they are charting a very different course. So it's time for us to chart a new course as well.
It's remarkable how much ground has shifted very quickly, I will say. And obviously we know this was not very quick in the big picture. The change on the court has happened over some years. But I think that you're right to point out that even the intellectual exercise of, how do we look at this test under the court's typical jurisprudence is not necessarily the right analysis anymore, because that ground shifts opinion by opinion. There's a question in the chat, a good question about emergency contraception. Some forms of emergency contraception may prevent implantation, which would occur after fertilization. And some of these laws that we're talking about, Bridget, that you've talked about, pending legislation, also in trigger bans, zombie laws, those apply at the moment of fertilization. Do we have reason to be concerned about bans on emergency contraception? Are we already seeing these? And what do we think the prospects are for that at the Supreme Court? Anybody can take that. It sounds like Fatima, you might want to jump in on that.
We should definitely be concerned about efforts to ban contraception, efforts to ban IUDs, efforts to ban IVF, efforts to to turn miscarriage and miscarriage management into a criminal violation. These are all things that flow pretty logically from some of the laws that have been passed. And what we've seen over the last 2 years as a political and cultural race to outdo each other. And at a certain point, you reach the end of the ways to be cruel about abortion. And so then you start coming up with a range of ideas. And all of this is along an arc and continuum, both in our laws, but in how people think about their own reproductive decision making. So the short version is, yes, it's coming. And so we shouldn't be surprised as we see it arrive more and more.
Probably not the answer people were hoping for.
That was not very sunny. I realize that.
You're allowed for sure under these circumstances. Adelina, what do you think of Griswold's prospects under the Supreme Court, given the alleged carve out for it?
So I don't know, honestly, that there are the votes to overturn Griswold the same way that there was this motivation to overturn Roe and Casey. But again, if you're looking at the court's reasoning in Dobbs about whether or not this particular right was protected in the 19th century, it simply was not. And so the court, I think, has a footnote that talks about, well, maybe the stare decisis analysis would be difficult or different with respect to those constitutional rights too. But yeah, I think it is naive to think that none of this is up for grabs at some point, either now or in the future.
Okay, so you're going in the not sunny basket with Fatima on this one. Let's see, I know we're starting to get short on time, but I want to get to as many of these questions as possible. Somebody asked, rational basis is extremely deferential and rarely invalidates state legislation, as Adelina, as you mentioned, especially considering the burden of proof on the claimant. What is the potential broader effect of this standard? What can you imagine would be the type of statute that wouldn't be upheld under a rational basis standard? Silence. Does anyone think there are any of the contemplated restrictions that this court would find not to be rational based on the analysis in this majority opinion?
I think the court, when it made clear we're going with rational basis from here on out, it listed, a dozen or almost a dozen ways that states could demonstrate this is our legitimate interest. And we know that based on, in this context and others, that the court is going to be highly deferential to any of these purported state legitimate interests. And so given that the court has offered its blessing to them, I think it is going to be an incredible challenge to strike down these laws as a constitutional matter, at least under the substantive due process clause of the US Constitution. State constitutions, a different question. Maybe some other constitutional amendments in the federal constitution under a different court, maybe a different outcome. But for now, these restrictions, they're not going to find a sunny bucket in this court.
And if I could just add, I think on the other side of that and what they're seeding and offering up for folks to make the next argument is a personhood argument, an argument that a fetus is a person whose weight is equal or maybe higher than whoever is bearing that person.
I think that's right too. One of the projects I'm working on now is what pregnancy regulation is going to look like after Dobbs. What a lot of people haven't, the discussion quickly moved to other constitutional rights like contraception, same-sex marriage. And what I'm looking at is the target that is undoubtedly going to be put on the backs of every pregnant person in this country, both because there will be motivation to be sure that nobody is having an abortion in the event that they're in a state that bans abortion, and also because they're moving or inching towards fetal personhood, which is the ultimate goal of the anti-abortion movement. And so what I think most people don't realize is that viability line that was in Roe and Casey saying the state cannot ban abortion, that line has been baked into other areas of reproductive rights law. So for example, states that have tried to intervene into wanted pregnancies where a mother is or a woman is in the process of delivering and wants to say deliver vaginally as opposed to a C-section, states have intervened to force a C-section, but the initial inquiry is, well, is the fetus viable? If it's not, the state has no business in this until that point. Now that that viability line is gone, what will state intervention look like in pregnancy? And we know that there will be just as much gaslighting in this context as you see in the context of abortion, that we are doing this in the interest of maternal health and the interest of infant mortality and all of those things. And it will be our jobs really to suss out whether or not this truly is for the benefit of the woman carrying the pregnancy, or if it is a form of gaslighting and ultimately control.
And I will say, so I'm a full spectrum birth worker and aspiring midwife. So this is like my jam. This is already happening, right? And I think that's the part that makes it so scary and dangerous, that like every day a person is giving birth and being forced to do something, and their consent is not had, even though there are laws on the books that says, hey, that's not what is supposed to happen. Or thinking about incarcerated folks who are being shackled to beds and delivering, where that's not supposed to happen legally. And so just thinking about the doors have already been halfway open and now they're fully open. And so we are having to do our due diligence and like continue to fight for folks, because the government does not necessarily care about us, is what this decision says to me.
Already happening here in California, right? The Attorney General just had to intervene in 2 cases, I think, coming out of a county to the east of us, in which women were prosecuted for having had miscarriages or stillbirths based on their use of controlled substances, which is clearly not allowed under California law, but they were prosecuted by the district attorney regardless. Yes, it's happening everywhere. I just wanted to point out that that includes California for all of us who are here. So the vigilance is warranted. You know, the reference to maternal mortality just makes me think of this statistic that was in the dissenting opinion. And we've brought it up several times today, the disparities, but just to put numbers to it, as the dissent points out, experts estimate that a ban on abortion increases maternal mortality by 21%, with white women facing a 13% increase in maternal mortality, while Black women face a 33% increase. The realities of that for maternal and healthcare in this country, which is already woefully inadequate, are pretty stark. Do we know what the plans are in terms of increasing access to either prenatal care or maternity care, given that there will inevitably be women, as Bridget, you've said, in the South in particular, but throughout and Midwest, but throughout the country, who are not able to access care?
I would just like to say the reality is, for many women, access is already inaccessible, especially those in rural communities and things like that, which we've already touched on, but this is truly a human rights crisis. And it's only going to it is being exacerbated by all of these abortion bans that are popping up. March of Dimes actually they do a maternal morbidity and mortality report every year. And I believe last year, the United States overall received like a C-, where Mississippi and Georgia received a D- and an F, I believe. So when we're looking at where these abortion bans are taking place, the people most impacted will be those that are already disproportionately impacted, and it's only going to increase from here.
Another statistic, I don't have it right in front of me, but from the dissent that leapt out at me, was they used Mississippi because that's the origin of the statute at issue in Dobbs, and they noted that in Mississippi it is 75 times more dangerous to give birth than to have an abortion, and that's with legal abortion, at least technically speaking, on the book. So it was a statistic that jumped out at me, and to get back to one of the things that Fatima mentioned, not something that's addressed in the majority opinion. And I thought it's a notable exception. And Kavanaugh's concurrence, I thought, was interesting in the way he kind of tried to point out maybe that there were things missing from the majority opinion, which I did not expect from his opinion. Overall, obviously, I think his opinion was problematic in a number of ways, including that it was assuring folks about the right to travel that doesn't appear to be at all clear from the majority opinion. But it did appear to try and kind of shine some light on some of the holes in the majority opinion. Do you think, Ederlina, in looking at the decision, if you're forecasting future decisions on choice, what would you think the court might take up in terms of a case? Obviously, as you said, they provided a roadmap of what will be a rational basis. Based on what's percolating in the states, what do you think is most likely to reach the court first in next term?
I think the litigation is going to look very different. What the Supreme Court or the majority opinion tried to basically say, in addition to Kavanaugh's, look, we're not going to be looking at these bans on abortion at 24 weeks or 20 weeks or 15 weeks. I think what is going to happen as a result of this patchwork legality of laws on abortion is the interjurisdictional conflicts are going to arise. You'll have interjurisdictional conflicts between the federal government and the states. So, for example, with respect to medication abortion, or what some people think of as RU 46, the FDA is trying to make very clear that this is something that should be available, accessible, and legal to everyone in every state, because the federal government, supreme law of the land, grounds of preemption, they should prevail. This is safe and effective. On the other hand, states are probably going to be fighting back and saying, no, medication abortion is not legal in our state. So that's one way that it'll pop up. And the court is going to have to resolve some of these preemption issues. Another way is going to be the extraterritorial issues that pop up between states. So if one state bans abortion and their residents travel to California, let's say, when that patient returns to their home state, can they face punishment? So that's going to be another issue. So all of the questions about federalism and the structure of our government, this court is going to be forced to have to decide. That's what I see coming up related to abortion with respect to the Supreme Court.
So there were a lot of questions about some of those points, particularly the interstate issues in the chat. And one of the reasons I didn't ask each of them to you individually is that I know that your answer is likely, we just don't know yet, because this is all very new and the old rules may not apply. So thank you for clarifying that so that folks don't think we're just avoiding the question. Would definitely encourage, if you haven't, to read that majority opinion, because it does provide quite a roadmap. As we're wrapping up here, we're talking about the legal future here. Would love a quick summary from each of you about what is most critical now in terms of what we can do with respect to the law. And if you want to address, I know particularly Bridget and Fatima that your organizations, as we said, have opportunities for pro bono lawyers, and we've dropped those into the chat. But anything else that you think that the legal community can do in response to the decision?
You know, I've been thinking a lot about how we're in a time where the law is uncertain. And so anyone who is trying to be a helper in this moment, whether you're an employer helping your employees, whether you are someone who's trying to help your community and engage in a community of care, is taking a giant risk alongside the risks that providers and patients have long been taken. And the thing that I would encourage lawyers to think about, and I know lawyers are risk averse by nature, we are trained to evaluate and think about and consider risk. And so the thing I want the lawyers to think about is your creativity with the risk of this moment and what these times call for. These are not typical times. These are actually really traumatic times. And I hope you all will be able to look at and think about when the Supreme Court undid 50-year-old precedent and upended the standing that people had in this country to control their bodies, lives, and futures. What did I do? And some of that might be thinking about risk a little bit differently. So that's my call to all of you.
How do you go after that? Fatima, I think you said it perfectly. Just supporting wherever you can, support providers, support patients, donate to abortion funds. That's literally the simplest thing you can do, is to give back. And also there are ballot initiatives, constitutional reforms, just being active in this moment, as Fatima said. So look at the federal and state protections that are happening. As mentioned, we have WIPA and each act, and also we can always fight for the elimination of the Hyde Amendment as well. So those are just a few ways.
Great.
And I will tag on to those and just remind everybody to try and be persistent. It feels like everybody in this moment, I think, wants to kind of throw their hands up and say, I don't know what to do with half of this country that just is not listening to reason or is not respecting civil rights and civil liberties. And I will say that, looking at the arc of abortion itself, the pendulum will continue to swing in our lifetime. And as long as we are persistent, it will swing in the direction that we want it to be. But that may not happen with the midterm elections, honestly, right? It may not happen as soon as we want it to be. But as long as we continue to go at it, I do believe that the pendulum will swing again. That's my opposition, my optimism note for the day.
And as the only non-lawyer, I'm gonna tell y'all what to do. But no, for real though, y'all need to step out of the lawyer talk, step out of the this is legal. Yeah, but most people are regular people that don't understand the language that you're using. And so remembering to step back into step back into reality. And that might sound rude, but step back into reality, step back into community, and make sure you're supporting folks that do not have the expertise that you have. And it's time, Fatima said, it's time to take risks. Especially grassroots organizers, people on the ground, clients that we serve. We've been taking these risks. We've been playing the game and hoping not to, get caught up in the terribleness that is the law and the criminalization system. It's time to step up and step out, and show up.
Well, on those notes, thank you all so much for today, for sharing your expertise, for being here, especially when I know there are so many demands on your time right now, given the immediacy of the decision. It seems like both 10 years ago and 5 minutes ago, but it has only been a few days. So thank you all so much. Thanks for sharing today. Thank you to everybody for attending. And we will look forward to continuing these discussions and figuring out the ways that we can be most constructive and most helpful.
Thank you, everyone.